This is Mitch Boyarsky. We're going to get started. We have at least 500 attendees on the call. We expect a few hundred more. So in order to get this going, thank you for joining us today. I'm a partner in Nelson Mullen's New York office, and today I will present with my colleagues, Rob Sheridan, Anne Murray, Roy Wyman, and June Lee on the subject of coronavirus workplace considerations for employers. We are all partners in various Nelson Mullins offices and represent employers for different workplace subjects implicated by COVID-19 or coronavirus. Nelson Mullins is committed to providing excellent services for our clients regarding coronavirus legal matters. All of our speakers are members of the Nelson Mullins Task Force, which is a multidisciplinary group of lawyers who regularly work with clients on a variety of subjects related to the virus, including technology, securities, banking, government relations, real estate, privacy, restructuring, commercial contracts, and education, just to mention a few. CLE applications are pending for this webinar. To request CLE credit, you will need to complete the survey that is sent after the program ends. In the middle of the webinar, Anne Murray will give you one of the passwords to get CLE credit. At the end, I will provide the other password. I want to thank the Nelson Mullins team for preparing us, including Beth Huffman, the head of our marketing department, Rachel Ortegon in our communications department, and our firm leadership, including our managing partner, Jim Lehman. I have to say that I am very, very sorry for the disruption the coronavirus has caused all of you. It is a difficult time that requires consideration of immediate and long-term implications. We need to be thoughtful and deliberate as employers, leaders, and people while understanding that situations can change. As one of our clients said to me this morning, this may be the year of working together apart. The challenges we face as employers is exacerbated by the significant legislative changes coming down the pipe, government agency guidance from employers, and pressure from federal, state, and local governments to significantly change the way we operate to prevent the spread of the virus. As an employment lawyer who has done this for 25 years and counseled employers through SARS, the H1N1 virus, anthrax, and 9/11, this is definitely one of the more challenging situations that I have seen for companies. The rate at which information is disseminated is unprecedented. The impact of social media also is seriously affecting the workplace considerations for employers more than any other crisis we've previously faced. Our goal today is to help highlight these relevant issues, focus on necessary compliance obligations and considerations, and if you decide you need assistance, work with you on positive results for those who reach out to us after this call. Rob Sheridan and I, both from our employment and labor practice group, will start with policies and procedures, including Rob will discuss a summary of the proposed Families First Coronavirus Response Act. I want to emphasize that this law is still going through revisions and is not yet law. Anne Murray from our corporate benefits and ERISA practice group will cover employee plans and retirement plans, health plans and retirement plans. Roy Wyman from our technology and privacy group will cover HIPAA, privacy, and cybersecurity workplace considerations. June Lee from our corporate immigration practice group will discuss immigration and employee mobility. At the end, we will answer questions. Since our time is a little packed, we anticipate a lot of questions, and we will provide an email for you to send questions at the end of the webinar after we're done. But again, we are going to cover questions at the end. This presentation is geared toward employers of all sizes and infrastructures. Perhaps you are doing many of these things already. If yes, keep up the good work. For you, this may just be a refresher. For those who have not yet taken these steps, consider using them as best practices. The more effective way for employers who are remaining open, and even those for whom their employees are telecommuting is for disrupting this virus to have employees wash their hands, stay away from the sick unless they're obviously taking care of them, sanitizing workplace surfaces that can spread the virus, and by social distancing. Be familiar with the CDC website and the WHO website that provides up-to-date and excellent recommendations for safety. For this reason, extra cleaning supplies, and assuming that's available still, and extra janitorial services are extremely important for offices and in our operations. At this point, there is very little travel taking place, and consider travel only where critical, such as for healthcare providers or logistics and transportation businesses, should you need employees to travel. If, by the way, an employee objects to traveling, I recommend you strongly consider complying with that employee's request. At this point, many entertainment, sports, and recreational events have been postponed or canceled. I don't see the reason why to hold an event right now, and not until any government or local official gives us more guidance to resume group events and gatherings. I just want to touch on task forces for a second. An internal task force for your company is a great way to streamline the decision-making process while getting collective input. You don't want to make knee-jerk responses without a sounding board if you have those resources. Include professionals such as outside counsel, health and safety advisors, and possibly financial consultants. If you have a task force, you can take credit for it with your employees and business partners to help build confidence in your leadership. I have fielded questions from clients about what to do when an employee reports an exposure. I have also received questions about what to do if an employee attended an event where another participant tested positive. Here are some answers. If an employee has been exposed, the employee needs to quarantine. If the employee merely was in the vicinity but no contact took place, you need to look more closely at the facts. When in doubt, it is better to isolate that employee and not to have him or her come to work. When making decisions affecting employees, you must make those decisions without regard to an employee's race or national origin. As an example, it could be discriminatory to tell someone who is Chinese or Italian to quarantine simply based upon national origin. Medical testing is another common topic. Medical testing is important and can help in light of virus considerations, but medical testing is not permitted under the ADA and possibly some state law unless it is job-related and consistent with business necessity, or there exists a direct threat to safety. You can ask an employee if he has tested positive or has been exposed. However, you cannot ask the person if he has diabetes or a heart condition, These disability discrimination laws do not protect family members or persons with whom an employee resides. I'm not suggesting, by the way, that you do an inquisition on employees about their family members, but just know that there's some more flexibility. Several clients have asked whether taking an employee's temperature is okay. Remember, employees can take pain relievers or other medication to mask a fever. Somebody's body temperature may normally be higher, even though they're not sick. But if you decide to do testing or taking temperature, I recommend that you obtain employee consent. Roy Wyman will talk more about certain privacy issues. As a general matter, employers do have an obligation under the OSH Act to safeguard their employees and to safeguard the workplace. That may not always be straightforward, but requires taking a common sense approach unless you are in a regulated industry, and then you may have some other obligations. Keep in mind that specific OSHA guidance was just issued several days ago that is available on the OSHA website. And I will repeat this for you, but I'll give you that website, which is www.osha.gov/publications/OSHA3990.pdf. Again, www.osha.gov/publications/OSHA3990.pdf. That guidance is a good checklist and is practical. A common question is whether workers' compensation covers an employee contracting coronavirus while at work or traveling for business. The answer is that if an employee could demonstrate that the exposure occurred while literally on the clock for an employer, workers' compensation benefits apply, so that you might want to consider providing workers' compensation paperwork if you know, and I stress know, that the exposure occurred while working. I would be careful in deciding how to deal with an employee reporting a workplace exposure and consider talking with counsel, especially if there is an ambiguity. I foresee that there being questions and perhaps challenges about where the exposure actually took place. I think there is a way to tell employees that they can apply for workers' compensation benefits. However, the carrier ultimately decides for eligibility reasons whether the employee actually will receive benefits. So at this point, I'm going to turn it over to Rob Sheridan.
Thank you, Mitch. This is Rob Sheridan, a partner in Nelson Mullins' Boston office. Thank you all for coming. Well, Corona is unfortunately here. So my first topic is leave availability. There are a couple different sources of leave here. The first would be kind of existing company paid leave policies. Company sick leave and PTO can be provided to your employees dealing with the coronavirus. The situation is going to depend on the circumstances and the particulars of your policies. But, this is a time where you could use reasonable judgment to exercise some flexibility so long as you do so uniformly. For instance, it's possible that you could extend leave even where employees are in a negative PTO bank so long as those employees pay it back. What happens when company leave is exhausted? Well, then the FMLA or other state equivalent leave can kick in, and we'll talk about that in a moment. Employees may be entitled to unemployment. The benefits determination is going to be made by the applicable state unemployment agencies. And there's also the opportunity or option to put employees on a furlough. We will also talk about furloughs. So what happens when a employee returns from leave after being afflicted with the coronavirus or taking care of a family member who is afflicted? You should consider, from the company perspective, an approach concerning certification from the employee that the employee is in good health, has been under the recommended period of quarantine, which the last time I checked was 14 days, and is otherwise symptom-free. Remember here that you need to consider both the rights of the affected employee as well as the safety and well-being of the workforce. Let's talk about statutory leave. The first source of statutory leave is the Family Medical Leave Act. There are two thresholds to keep in mind with the FMLA. The first is the head count threshold. The FMLA is only going to apply to those employers with 50 or more employees within 75 miles. There's also a service time component for the employees, which is as follows. The employee has to have worked for the employer for at least 12 months, and they have to have worked for at least 1,250 hours over the past 12 months. What does the FMLA provide? Well, it provides 12 weeks of job-protected unpaid leave for, among other grounds, medical leave when an employee is unable to work because of a serious health condition, and we'll talk about that, or care for an immediate family member with a serious health condition. There's been an open question, and I've gotten inquiries from clients about whether or not corona would qualify as a serious health condition. It is still an open question, but the answer is likely yes. Transitory ailments like the common cold or the flu are generally not considered serious health conditions. But I think because of the CDC guidelines on quarantine, as well as the variety of complications corona can cause, corona would likely qualify. The main benefits of FMLA leave from an employee perspective is that while FMLA leave is unpaid, it generally is job protected, such that the employee has to be restored to the same or an equivalent position. In addition, the employee is allowed to continue their company health benefits. There's also protection against retaliation for exercising rights under the FMLA. So be wary of that as this matter evolves. In addition, there are state leave benefits. Many states have adopted different schemes with respect to paid leave and paid sick leave. We suggest here that you contact counsel to make sure you are complying with all applicable leave schematics as they're evolving and oftentimes overlapping. And as Mitch mentioned at the outset, state legislatures are changing these laws as we speak. There is, in addition, the bill that folks think is likely to pass that Mitch mentioned. There are two main components of this bill from a leave perspective. The first is the emergency family and medical leave component. First thing to remember about this, as it's currently constituted, is that it's going to apply to private employers with less than 500 employees. There's a requirement that employees be employed for 30 days to get benefits. The benefits are as follows: up to 12 weeks of paid leave for self-quarantine due to coronavirus affliction, care for a child who is out of school because of corona closure, or care for a family member with corona. One of the interesting features of this bill is that the first 2 weeks of leave, at least under this component, may be unpaid, but an employee could always substitute vacation or sick time during this waiting period. After the 2 weeks, employees are paid 2/3 of their monthly salary, up to $4,000. This leave is job protected unless the employer has under 25 employees and can establish certain conditions like a material change in economic circumstances. In addition, employers with fewer than 50 employees may be exempted, so stay tuned for the final law and the regulations interpreting that law. The other key component to this bill is emergency paid sick leave. Again, this is going to apply to employers with fewer than 50 employees. It will provide an employee with 2 weeks, i.e. 80 hours or 10 days of fully paid time to quarantine or seek diagnosis for preventative care for corona. Part-time employees are also eligible on a prorated basis. It also provides for 2 weeks of paid sick time at 2/3 the rate of pay if the employee is caring for a family member with corona or a child whose school or daycare is closed for corona. The most striking feature of this portion of the leave is that it's available for immediate use by an employee, regardless of how long the employee has been working for the employer. An open question about this bill is the interplay between these two different types of leave, and this is really still being fleshed out. But it may be that qualifying employees could use emergency paid sick leave during the waiting period for the Emergency Family and Medical Leave Act. I would think of the example of somebody who is afflicted with corona, is quarantining at home, and then their family members become afflicted with corona as well. So, the first 2 weeks, they could utilize the emergency paid sick leave portion, and then the second half of that would be covered by the emergency, family, and medical leave portion. There are some other considerations with respect to leave which raise some tough questions. Number one is whether your company policies are going to apply to self-quarantine. This can be somewhat of a moral hazard issue, and there will undoubtedly and unfortunately be some abuse, but erring on the side of the safety of your employees in this situation is likely the best bet. Another concern here is that if you grant leave to ineligible employees, you may be creating a de facto policy. So tread carefully, and whatever you do it in an even-handed manner that makes a determination based on business necessities and safety considerations, and does not discriminate based on a protected class. Here, I think what we know at this time about corona is that it's particularly virulent with the elderly. So here, be very careful of exclusionary policies with respect to your aged employees. Finally, in a unionized setting, be sure that your policies comply with any applicable collective bargaining agreements. And if we could turn to the next slide. Okay, there are a couple of options that unfortunately are very prevalent right now, and everyone should be attuned to with respect to dealing with an economic slowdown due to corona. Number one is reducing hours. So if you're reducing employees' hours, there are going to be wage and hour implications. And I'll break this down between exempt and non-exempt employees. And when I say exempt, I mean exempt from overtime obligations. For exempt or salary employees, if these employees work any time during a work week, they're generally entitled to their full salary. For non-exempt employees, they're only entitled to pay for hours worked. So if they're doing no work and they're otherwise not entitled to paid leave, then the baseline is that they're not going to be entitled to pay. A reduction of hours also has a variety of implications that a company must be attuned to, including the potential that employees could lose exemption status by falling under salary threshold. With respect to benefits and reduced hours, my colleague Anne-Marie is going to discuss this in detail, but the other potential implication is that all else being equal, employees could lose benefits eligibility as their hours go down. Another option that many companies are considering or implementing is involuntary furlough. A furlough is a mandatory suspension from work, and it's generally without pay. It can be as brief or as long as an employer wants. Many companies are implementing or considering furloughs in lieu of or in tandem with layoffs. What's the key difference between a furlough and a layoff? Well, a furloughed employee generally has an expectation of a return to work. And in addition, generally speaking, a furloughed employee will retain their benefits. Compensation issues with respect to furloughs. The key during a furlough is that no work can be done by the employee during the furlough. This means likely cutting off access to work, email, and media, because once an employee does any work during a furlough, a payment obligation is triggered. And this, again, has implications for exempt and non-exempt employees. For non-exempt, it's not as difficult to administer from an operations point of view, as employers do not have to pay non-exempt for time not worked. But for exempt, any work during a work week, i.e., answering that single email, would entitle the exempts to their full salary during a work week. One of the last things to consider with respect to compensation is that furloughs can be structured to maximize unemployment benefits for employees. Another thing to think about with furloughed employees is access to facilities. Generally speaking, access should be restricted to furloughed employees, but the call should be made based on the business needs and necessities of the company. As I had mentioned, there are some technological considerations, and the first is to consider restricting email and company media access to furloughed employees. For instance, in this matter, when you're furloughing an employee, it's very important that their media access is cut off so that the company can maintain their confidential and trade secret information under lock and key. Okay, besides furloughs, you also have layoffs and plant closings. Unfortunately, we are now in the zone where WARN Act has come into play, and many companies need to consider its implications. The WARN Act is a federal law that applies to employers with 100 or more employees and requires 60 days notice of termination to affected employees in the event of a mass layoff. What is a mass layoff? It's a reduction in force within a 90-day period that results in employment loss at a single site of employment of either 1/3 of the site's employees and at least 50 employees, or 500 or more employees, or a plant closing. The WARN Act has some aggregation rules. So if you're planning on a series of mass layoffs in a quick succession, it's best to speak with your counsel now regarding compliance. In addition to the federal WARN Act, many states have so-called mini WARN Acts, and they may have lower thresholds and different notice provisions and other features. So again, companies have to consider all the applicable statutory schematics in tandem. There are also non-WARN reductions in force. One of the things to remember here is you still need to follow appropriate protocols for group layoffs, including, for instance, review and revocation provisions under ADEA and the OWBPA for any affected workers who are over 40. Unemployment options. Many states right now are changing their rules regarding unemployment eligibility and eliminating waiting periods. While the benefits determination is ultimately up to the specific states, if employees are laid off, they're generally going to be entitled to unemployment benefits. We could go to the next slide. Many of you are probably listening to this webinar from the confines of your home office. Remote work has become a reality here. One of the first things to think about with respect to remote work is whether it's going to be feasible for your organization. And ultimately, that's going to depend on your business, your employee base, and your technology. Another key thing to think about with remote work is, again, exempt versus non-exempt employees. For exempt employees, any work done in a given week is compensable salary. And for non-exempts, of course, they're only paid for their hours worked. And because of that, for non-exempts who are working from home, you need to make sure to have appropriate protocols and technology in place to track hours. With work from home being a reality, companies need to think about ways to enhance and foster productivity. There are many, many available options for technology that will enable face-to-face communications like Zoom or GoToMeeting. I suppose if there's any upside to this situation, it's that work from home has been a reality for about a decade, and that companies have existing procedures and policies that have worked and can work for other organizations. Given this reality, if your company does not have a remote work policy, now is the time to implement it. There are a host of issues related to remote employees and eligibility, and I just wanted to give a couple examples here. So the first example would be an organization whose office is in New York City, but it has employees who are working remotely in New Jersey. After a certain amount of time, it may be an open question as to whether these employees are entitled to paid leave under the New Jersey or the New York schemes. Following up on that, as I mentioned, different states have different rules regarding unemployment. This same employee base may have an issue with respect to whether or not they need to apply in New Jersey or in New York for unemployment. To make remote work a reality, you need to make sure that your technology is up to snuff. If you haven't done so already, the time to stress test your systems is now. My colleague Roy Wyman will discuss this in detail, but you need to ensure that your remote systems continue to comply with the web of state and federal laws regarding data privacy, and of course, for many employers, the GDPR. You should also take all appropriate steps and institute protocols and notify your remote employees about their obligations regarding data privacy and protecting company trade secrets and confidential information. Finally, and this is a question I've had before, is what about individuals who have limited connectivity, and what can organizations do to help? In these instances, you should consider providing your remote employees with the appropriate media, jetpacks, and perhaps stipends for getting the necessary connectivity to do work remotely. Finally, with remote work, you need to be rigorous with respect to wage and hour issues. That means accurate and appropriate timekeeping and record-keeping measures, and companies need to avoid or mitigate any off-the-clock work. Thank you.
Thanks, Rob. This is Ann Murray. I'm a partner in the Atlanta office of Nelson Mullins, and I'm going to talk us through the issues involved with employee benefits. As we all know, these are quite valuable, especially given COVID-19's impact to our employees. And so we want to make sure that each of you as employers is thinking about all the different benefits that may be helpful to your employees, but also that may be impacted by some of these furloughs or leaves or reductions in hours that you may have to implement as a result of COVID-19. So I want to start with a difference between fully insured and self-insured health plans. I think it's very important that everyone understand when we're hearing things in the news about what insurers are saying they're going to do, that we focus on what type of plan we're sponsoring. For example, you may have heard last week in President Trump's address that insurers had agreed to waive copays on testing, and I think he went a step further and said it was applied to treatment as well. But since that time, that has been corrected. Insurers have agreed across the board to waive copays on testing only, but not as to the treatment. So it's important that that if you have a fully insured plan, that's going to apply to you. But that's where I want you to realize that if you are a self-insured plan, this is not an automatic provision that's going to apply under your plan. It actually takes you reaching out to your broker or your consultants or attorneys that you work with and amending your plan to specifically waive the copays on testing. If you want to go a step further and waive copays on treatment and other COVID-19 related benefits, you can do that, but you need to talk it through and make sure that if you're self-insured, you are amending your plan. If you want to go a step further and you're a fully insured employer, you've really got to get with your broker and then talk with your insurance company to see what they're willing to do. Because if you're fully insured, you're kind of locked into what that policy provides. Note that in some states, for instance, New York, the state has come out with mandates for insurers that operate in its state. New York, for example, is requiring insurers to take additional steps to cover COVID-19 related costs. So check with the states in which you have employees and in particular where you are offering insurance, if you're fully insured, to find out what the mandates are, what you need to be complying with. There's a lot of issues that can come up, or some of you may have heard, if you offer high deductible health plans. Those are the type of plans where they're coupled with health savings accounts, and in order for employees to qualify to be able to contribute to these health savings accounts, their high deductible health plan has to not provide first dollar coverage for certain benefits until they have satisfied their minimum deductible. So there was a big concern that, well, what if, for example, you have you want to go with one of these programs like the insurers had announced where you're going to waive COVID-19 testing fees. Oh my gosh, what's that going to do to my health savings account? Well, we thought at first that was going to create some issues, but the IRS actually came out with Notice 2020-15 just within the past week here, where they have basically said that until further guidance, a health plan that is trying to operate as a high deductible health plan is able to waive the copays and deductibles and other limits or costs that you're passing on to the participant on COVID-related testing and treatment. So that's a big savings for employers, because we weren't sure about this. And granted, you're going to have to do what you're going to have to do and what you think is best for your employee population, but it's something that was certainly creating some concerns for employers. So a bit of good news there that the IRS is already coming out and trying to support you. On a related note, the pending HR 6201 that was passed by the House and that is awaiting, hopefully, Senate approval will require that private health plans cover COVID-19 testing. So that will potentially, depending on how they interpret it, that may potentially impact those of you that are self-insured and mandate that you actually take that step to provide the testing. Now, you may have heard in the news that some of the insurers have gone above and beyond. So, for example, let's take Edna, as they've rolled out a 5 or 6 element COVID-19 program where not only are they waiving copays for things like COVID-19 testing, but what they're doing is taking it a step further, and they're offering, for example, a 0 copay for all telemedicine visits for the next 90 days. So that is if your child has an earache, if you have a stomach ache, things that are not even related to COVID-19. Their point is that they are doing this and expanding telemedicine so that people are not in doctors' offices where they might be more likely to catch it or where they might be using up doctor services that are needed for COVID-19. The big issue here, though, that I want to point out to everyone is this goes back to what I was highlighting with fully insured versus self-insured plans. If you are a self-insured plan and the insurance company that's operating your plan as an administrator comes to you with this type of broad-based expansion of your benefits, you need to make sure that you're talking with your benefits consultants and, in particular, with your attorneys, because adopting such a broad provision could invalidate your high deductible health plan, health savings account offerings, and could actually result in some unintended taxation of your employees. For example, Aetna's program, if someone is diagnosed with COVID-19, actually sends them a care package with over-the-counter drugs and Lysol wipes and a whole bunch of other things. I don't know if they're Lysol, but they're antibacterial wipes. So those types of things, you just need to kind of take a step back, and as much as you have good intentions, you also don't want to create bigger issues down the road for some of your plans. Now, another place where I think it's important for employers to focus is who is in your plans, and who's going to have benefits available to them. Are there groups where you aren't currently offering coverage? And if you aren't offering coverage to those groups, is there, just from a employer perspective, is there any reason that maybe you want to go in and put in place any types of benefits? Be careful, because going with the idea of no good deed goes unpunished, let's say as an employer you were to, say, well, I just want to say I'm just going to reimburse every one of my employees for their testing, their COVID-19 testing, regardless of whether they're in our plan. That's a great thing to do, a great benefit to give your employees. But the unintended consequence, at least under the law as it currently stands, is that you could be creating what we would call a group health plan that has limits in it that don't comply with the Affordable Care Act, and it could subject you to significant dollar penalties as a result. So make sure that before you kind of go forward and just start putting in place these programs, that you're talking with your broker and your legal professionals to make sure what you're doing is compliant. As we look at some of the cutbacks that some employers may need to adopt, as Rob was talking about, these furloughs or mandatory unpaid leaves, consider how that's going to impact who is covered by your plan. For example, if you are an employer, and this is one of probably the smaller percentage of employers, but if you're an employer who's subject to the Affordable Care Act mandates, where you have to offer coverage to all your full-time employees, and if you've chosen to measure those employees' hours on, let's say, a month-to-month basis, if you impose a mandatory unpaid leave or furlough for a month or 2 months, they could lose their eligibility and no longer be treated as full-time employees for purposes of your plan. And so, at the time when they need it most, they might not have health plan coverage in place. So talk that through and consider it as you're implementing these layoff programs or leave programs, just to consider, are there going to be COBRA rights? Is this going to jeopardize certain people's eligibility for coverage? And what steps can I or can't I take, to amend my plans to maybe, fix that or try to provide more coverage? As far as expanding limited benefits, I already talked about the potential ACA penalties, but just think about other areas where you might be able to legally provide added benefits to your employees. On the next slide, we list some of those possible areas to think about. For example, telemedicine. This is one that you're hearing more and more, and I think a lot of employer plans have already moved to offering telemedicine. If yours doesn't, and now may be the time to be reaching out and finding out if it's possible to add it in there. But if you are adding telemedicine, as I talked about on the last slide, consider what types of conditions that telemedicine is going to be available for and how those copays will work. As I said, it's fine to have testing and treatments and waive the copay, but if you're going to go that expanded route of offering telemedicine for every condition, I think that's going to get some people into potentially, some problems and triggering some penalties. So talk that through with your advisors. Nurse helplines may be particularly useful at this point. Admittedly, that's one of those underused benefits that I've found in group health plans, but you may want to find out if that is available through whether you're fully insured or self-insured, and make sure you advertise it to employees. Let them know, here's the different things within our plan that might be of use to you right now. Because I think with everyone, so many people moving to remote, they're starting to feel isolated and trying to find maybe one spot, maybe having a frequently asked questions that focuses on COVID-19 and the things within your plan that could help people. That may be useful to the employees. You may, whether it's through your medical plan or your employee assistance program, you may offer counseling and outreach to those who admittedly might be finding that they're overstressed as a result of the COVID-19 risks. For those of you who offer on-site clinics, especially those in the manufacturing side, Also be careful there. On-site clinics can be treated as a group health plan and subject to ERISA if they provide anything more than some very limited preventive care and maybe kind of first aid services. So while it may sound like a great idea, hey, we've got an on-site clinic, on site, and so why don't we go ahead and just get some testing kits when they're available and offer something there. Make sure that you're considering, am I just doing testing? Is this permissible? Or am I treating? And if I'm starting to treat, then you may be triggering all different ERISA requirements, HIPAA requirements, state licensing requirements, especially if you directly have hired your on-site nurse or doctor. So there's a lot more to it, and make sure that whoever is working with you with your on-site program is that you're reaching out to them and talking to them about what can be done. Okay, next slide, please. So at this point, I'm going to give you the code word to be submitted for continuing education. Our code word is virus. Code word again is virus, V-I-R-U-S. Okay, continuing with group medical and other benefits. So, think about what actions you can take now to help your workforce. I think I'm seeing the majority of employers that I'm talking with moving towards waiving copays and other limits that apply to the COVID-19 testing. We don't have a vaccine yet, and we don't know when we will have a vaccine, but that may be another area where you're going to want to consider waiving copays and other limits. As we talked about, the impact on your high deductible health plan and HSA contributions, thanks to the IRS guidance, that's not an issue if you are going ahead and waiving copays and deductibles for testing and treatment. But if you're going above and beyond, make sure that you talk with your professionals. If you're self-insured, consider what's going to happen with your stop-loss policy. So if you waive some of these copays or you broaden some of your coverage, what's really important is when you are issued a stop-loss policy, that policy is based on your plan at the time that you are buying the stop-loss. So it's very important that you work with your broker to send any plan amendments and get them approved by your stop-loss provider. You don't want to, from a business perspective, you don't want to spend all this extra money and then find yourself without stop-loss coverage or having invalidated the stop-loss coverage as a result. Next slide. And then finally, on the group health and welfare side of things, think about, or on group medical side of things, think about leave and furlough related issues. Are you going to, if you're going to mandate that people take unpaid leave or go on an unpaid furlough, don't assume everything stays in place. While we're finding that insurers are pretty receptive to working with employers and trying to make sure that coverages stay in place, you need to get their approval. So make sure you work through your broker to get an addendum or some type of something in writing from the insurer that's saying, yes, we understand you're implementing this unpaid leave or this furlough, and we will keep this in place. So contact your broker and check your policy or your plan document if you're self-insured, and just make sure that you're not going to be triggering something that causes someone to lose coverage. As far as premiums, when you're talking about go back one slide, please. As far as premiums go, make sure you focus on how your employees are going to continue to pay the premiums. If you put them on an unpaid leave or furlough, you need to think about, are you going to go ahead and pay all the premiums on their behalf? And if so, you need to put a policy in place that makes very clear, hey, this is going to need to be repaid when you come back, or maybe not, up to you. But also, how are you going to recoup costs if someone does not come back? If they don't return and you want to be able to deduct those premiums or seek repayment, you need to make sure that that is clear in writing. If you want to be able to recoup those costs out of perhaps some severance or other benefit that the employee may get down the road, most states are going to require that you get something, or many states are going to require that you get something in writing from the employee agreeing to that wage deduction. So consider that. Next slide. And then finally, on the employer group medical, consider putting out some type of frequently asked questions for your plan participants. As I said, most people are a bit isolated if you've moved to a lot of remote workers. So if you're making changes, consider distributing some sort of, here's our program. And it kind of gives this, optically, the idea, going with what Rob and Mitch were talking about, of we've got this handled. We've got all these programs in place. Think about advertising or communicating to your employees that in their flexible spending accounts, if you offer a dependent care flexible spending account, some of these employees who may have been eligible for that but didn't enroll are now seeing their children being, sent home, where now they have to go out and find at-home care. That may qualify as a family status change that enables them to make an election through their dependent care FSA to go ahead and pay for those costs on a pre-tax basis. Every little bit counts right now. Employee assistance program, check what yours offers, counseling, all of those sorts of things. Your short and long-term disability policies, review those carefully. A lot of people adopt short-term disability as a payroll practice where it comes out of your own pocket. If it is, review your definition of short-term disability and make sure, for example, if someone goes out on an unpaid furlough and then gets COVID-19, how's that going to work? Are they going to be entitled to short-term disability, and what's their pay going to be measured as? Should they get more than someone who didn't get sick? You can probably see where that's going. And then ancillary coverages. Consider what's out there and what may be in place and highlight that to your employees. There's a lot of HIPAA privacy protections. Roy Wyman is going to be up next, and he'll be talking about those. But just keep those in mind as you are having employees come forward, or you're finding out that employees are suffering from some of these conditions. Next slide. Now we'll talk about qualified retirement plan considerations. So there's a lot of issues with qualified retirement plans that, a lot of areas that are impacted by the COVID-19 scare and everyone's reactions to COVID-19. First, fiduciary obligations. Remember, as a plan sponsor of any type of qualified retirement plan, typically as the plan sponsor, either you, the company, or maybe a committee that you've designated, is acting as the plan administrator and making decisions as to investments. There's some exceptions to that, but just as the general rule. Remember that you have fiduciary obligations, so you have to act prudently with respect to investments. That may mean, if you have not already talked with the investment advisors for your plan, you need to make some phone calls and make sure that you document that you're checking in with them and asking the important questions like, are there any changes I need to make within the lineup in my 401k plan in reaction to what's happening in both the U.S. stock market, but also foreign investment funds? If you are lucky enough to have a 401k where perhaps your investment advisor offers some one-on-one services for participants, you may want to get some of those signed up so that your individual employees can call and talk one-on-one with the investment advisor to find out if there's changes they should make. And if you have a pension, defined benefit, or cash balance plan, remember, all of the responsibility then is on your investment committee or whoever is the fiduciary in charge of investments. And so, once again, you're going to want to make sure that you show that you have checked with the experts you've hired, the investment advisors and managers, and that you document that you've reached out to make sure there's nothing that you need to do to change investments or react. Next slide. As you talk about the things that you can do to help your employees, sometimes qualified retirement plans, as wonderful as they are, there are areas where there may be some ongoing costs for your employees, in particular 401k loans. You may have employees right now who have sizable 401k loans they've taken out of your plan. And if you put them on an unpaid leave, unpaid furlough, or even a reduced pay, consider whether or not you're going to be able to suspend 401k loan repayments during this time. There are ways you can do that, in particular if someone is on an unpaid leave. It's for a limited period, and we can certainly talk you through that, but you need to consider that because you don't want to put someone in a position, if you can help it, where not only do they not have pay, but they also still owe money to your plan and are going to have trigger penalties as well as taxation. If you have a limit on the number of loans in your 401k, you may want to consider opening that up to a higher number of loans because some people may have already reached that limit, and especially if you're putting in place a furlough or unpaid leave, they may need that extra source of funds. Hardship withdrawals may be another area where your employees can look to take some of their 401k money to help them get through this hard time. It depends on how you've defined hardship withdrawals within your plan. Check the plan definition to see whether or not you follow the safe harbor, which safe harbor does include expenses for medical care for the participant, their spouse, their dependents, or their primary beneficiary. If you have not adopted the safe harbor and instead adopted what we call the more general rules, it's a facts and circumstances test, but you'll want to talk with your advisors about, does this qualify as an immediate and heavy financial need under the general rules? Just make sure you've kind of checked each of these boxes off. For those of you who have a 457B plan, just know a hardship distribution can only occur there if there's what we call an unforeseeable emergency, which is a severe financial hardship, includes a severe financial hardship that results from illness. So I would expect that, that this is going to qualify for a distribution in a 457B, but certainly talk with your advisors to make sure that they agree. And then think about if you are, it's unusual nowadays, but you may have limits in your plan as to when people can cancel their 401k or 403B deferral elections, when they can cancel or change them. Given the way that the stock markets are moving, you may want to consider, if possible, making it easier for people to make fast changes to their deferral elections. Next slide. And then focus on, for those of you who are feeling the impact of the COVID-19, think about some of the ways that you might be able to minimize both your risk as well as your potential liabilities. If you have not made 2019 discretionary contributions to date, there may be an opportunity to modify what you're going to make. If you have a safe harbor plan, there are specific rules that may allow you to amend that promised safe harbor contribution mid-year, but there's limits that apply. Basically, you have to have either had some certain language that was in your safe harbor notice, or you have to be able to show that you're operating at an economic loss, which may not be difficult, but talk with your advisors, because that may be a way that, rather than making a safe harbor match or non-elective or committing to that at this point, you take the view of kind of let's wait and see. If you make full year contributions, if you make pay period contributions, for example, if you contribute your match every pay period, you may want to move to doing that at year end just to kind of free up those funds. And also, if your plan provides for that you will automatically make non-elective contributions to save your non-discrimination testing. This is if you're not a safe harbor. You may want to consider changing that, where you return people's money instead, rather than contributing out of your pocket. But stay tuned for special exemptions that may be issued by the IRS. This may be considered for some of the disaster relief that we've seen the IRS come out with when there's been other hurricanes and other disasters in areas. Next slide.
All right, it looks like that's for me. Thank you, Ann. This is Roy Wyman. I'm a partner in the Nashville office, as you can see. And this is a very interesting time, I think, for all of us, but particularly when looking at privacy issues. There is a definite tension that's risen in our culture generally between individual welfare and where we see our privacy rights. And this coronavirus, COVID-19, has brought that really to a head. And as we're looking at this, and it's a very fluid situation, some of these are not really subject to easy answers. We haven't been through this before. So what we're doing is really trying to create a method to think through these issues. And what I want to help you with today is to have a method to analyze the questions and make rational choices so that a month, 6 months, a year from now, you're not second guessing or having, even worse, a plaintiff's attorney second guess what you did at this point. I will give you just an example real quick, is that just today discovered that the U.S. government is looking at using bigger companies like some cell phone providers as well as Google and others to geolocate individuals who have the coronavirus. In other words, they would track your cell phone and know where you are if you have the virus. These are major issues. This is a major breaking point, really, I think, for our society. And you all are at the head point of that. You all are dealing with this day in, day out in the trenches. So thank you. So for this, one of the questions that I get a lot is one that starts with the question, will HIPAA let me? And people are very much concerned about HIPAA who have never been before. And generally my quick answer is that if you do not worry about HIPAA on a regular basis now, this probably isn't going to change that. HIPAA applies to two varieties of entities. One is called a covered entity, and the other is called a business associate. A covered entity is simply a healthcare provider, a health plan, or a clearinghouse. If you don't know what a clearinghouse is, you are not one, and therefore you don't need to worry about this. You'll know very much if you're a clearinghouse. Providers are folks who bill insurance generally for actually providing care. So we're talking about licensed providers, usually hospitals, doctors, nurses, those sorts of folks. Again, this is something that you'd be dealing with regularly. If you are just a standard employer that does not handle health and provide clinical care or pay for clinical care on a regular basis, HIPAA is not likely to cover you, or unless you're a business associate, that is a vendor who provides services to a covered entity. But for most purposes, where HIPAA would impact you is with your plans. So if you've got an employer plan, often those will be handled by a third-party administrator. And that third-party administrator takes the hassle away from you so that the employer does not have to worry about HIPAA issues and coverage on a regular basis. In that situation, those employer plans should have firewalls in place already. In other words, the information that is received in order to handle the plan is kept separate from information that's used as an employer. So the employer can ask questions of an employee that do not relate to, caring for that employee as a provider. And that's perfectly appropriate. Somebody calls in sick, HIPAA does not cover that. Where it does cover it is information regarding claims that are filed. So keeping the claims filing and the information about health care separate from information as an employer will generally protect you. So yes, HIPAA is probably not going to limit what you're doing unless you are a covered entity or handling information on behalf of it. Now, one of the things that has happened is that there has been a waiver of certain penalties that normally would be levied against hospitals. So if you happen to be a hospital provider, you are able to do things like discuss health with friends and relatives of a patient that you might not otherwise do if that patient has the coronavirus. Things like opening up hospital directories. In emergency situations, the hospital may not always give out a notice of privacy practices, things like that. There's been some relaxation. One question that I do get, and that does come up, is if an employee is ill or shows up for work and just doesn't look right, can you send that employee to a physician, a hospital facility, and demand to get information about that employee's health? In other words, I want to know, is this person infectious so that I can send them home? Now, HIPAA isn't completely implicated by that, but it is to an extent. You cannot force an employee to be treated or tested. You cannot force them to be diagnosed. You can't force them generally to go to a doctor in most situations. But if you, as the employer, are paying for a physician to look at an employee for that purpose, you can tell that physician, I want you to get the employee to sign this authorization that allows you to disclose information about, say, their test results to me. And I'm not saying this is a good idea, but under HIPAA, this is permitted if that employee is then told, you can sign this, or else you can pay for it yourself, or you can go home. You don't have to be here. You do not have to sign this authorization. But if you want the COVID test and you want it paid by your employer, then please sign this authorization. Mitch, go ahead and next slide. So how good of an idea is it to test your employees, to take their temperature at the door? Part of this is going to depend on where you're at. If any of you have facilities or employees located in the European Union, GDPR is very much implicated by this. And as with a lot of things, it's not completely clear, and it may vary by the country that you're in. I will say that the European Data Protection Board chair came out with a statement that the GDPR, that is the privacy protection regulations covering the European Union, by her words, does not hinder measures taken in the fight against the coronavirus pandemic. But she said, even in these exceptional times, the data controller, that is you, in essence, must ensure the protection of personal data on the data subjects. Bottom line of this is that they are not giving you any leeway. They don't care that it's a pandemic. You must protect the privacy of your employees. One of the things to keep in mind is one basis for using and collecting information is if the person whose information you're collecting gives consent. Be careful here, though, because there's a lot of guidance in the European Union that because the relationship between an employee and an employer is not equal, that consent in essence is impossible. So if you are relying on consent, you cannot get consent from your employee is kind of the bottom line. And they will argue and perhaps will succeed in arguing that that consent was not given freely and therefore was not sufficient. However, like I said, this is a nation-by-nation approach, and there are other bases for being able to collect information from your employees. So, for example, in Spain, there's been a statement that you can use information to prevent occupational hazards under Spanish law. So, in Spain, if you believe that an individual could be a hazard to their own safety or the safety of others by coming to work, you can do things like collect information and use that information. So look at the state law in a nation-by-nation basis. Here in the U.S., I'm often asked about biometric laws, and these are laws that prevent employers and others from collecting biometric information such as retinal scans, thumbprints, palm scans, those sorts of things. These are implicated in the states of Illinois, Texas, Washington, California, New York, and Arkansas. None, though, are likely to apply here because they are either limited to collecting information for identification purposes. In other words, I'm doing a facial scan to identify that you are who you say you are, or they limit your ability to use that for commercial purposes. But generally, those statutes do not explicitly say that you cannot collect somebody's temperature for health-related purposes. Now, one little aside here, if you're doing business in the state of Washington, do not take anybody's temperature or otherwise collect any sort of biometric information and store it in a database unless you've really looked at the Washington law and can comply with that. But if you are collecting information and then, shredding it, that's going to be permitted here. So, bottom line is, it is not specifically illegal under state statutes to take someone's temperature or collect that information. However, it may not be a good idea. You have to be very sensitive to the context and be reasonable in how you do it. Simply willy-nilly collecting everybody's temperature, folks may feel like their information, their privacy is being invaded. And if it turns out that you never have any cases, that employee is going to come back later and say, you overdid it, you invaded my privacy, and I'm going to bring up a claim. And there are claims out there to be had. There are common law rights, ability to sue of individuals that are not statutory, things like invasion of privacy. Another one that likely would be brought up is what's called false light, and that is spreading true information, but in a way intended to hurt somebody or put them in a false light, even though the information is correct. So what do you do? I would say that if an employee is ill, obviously send them home. And if that person does have COVID or some other disease that could impact others in that workplace, you're really walking a tightrope between negligence that could cause a further outbreak versus violating their privacy rights. So I would definitely say get counsel around these, think about the potential claims on both sides, and be able to document what you do in a way that shows that you were reasonable no matter how it ends up going. Next slide. One of the areas that's definitely come up and that's been talked about a little bit before, even on this call, is sending employees home to work from home. If you do not typically have folks working from home, all kinds of issues can arise if you have not really addressed the ability and hygiene of that. One of the first things to think about is that person going to log into our network from a distance, and is that a secure transmission? Do you have a virtual private network, a VPN, secured socket, some other way so that that information is encrypted in transit? And do you have ways for them to log in that not everybody can? So, for example, I read a report of a German local area agency, governmental agency, that sent everybody home and then had a conference line that people could dial in to have a meeting to discuss COVID. Well, the problem was it wasn't actually a secure line, and anyone who wanted to could dial in. So if you haven't tested these things out in the past, you have to be very careful about setting it up, because you can't just throw it all together at the last minute. There are issues here around it. Additional issues that have come up. Just while we've been talking, the Department of Health and Human Services sent out a warning of increased cyber scams that are out there. There's been a big increase in phishing attacks, people sending out emails with links saying, if you want to track where the COVID virus is, click on this link. Well, you click on the link, and what it does is download a virus onto your machine, which can create all sorts of breaches of secure information, major concerns. Wi-Fi. Do your employees have secure Wi-Fi at home? Are they going to the local Starbucks? Making sure that those are done well. Have policies in place, and if you have a contingency plan, follow that contingency plan. If you do not have one, get one in place as soon as possible. Have an incident response team, have their cell phone numbers known by everybody, get a list of outside contractors, media, legal counsel, others that you need in order to be able to get a hold of everyone, have calls to handle this on a going basis, and implement it, and use this to have something in place for the next time it happens. And with that, I will hand this off to June Lee.
Hello, everyone. This is June Lee. I'm a partner at the Atlanta office of Nelson Mullins. I'm in charge of the career practice team, and we are handling business-related immigration issues. We have been inundated with calls every day for a week or so or more, and it seems like the information is changing every day. When I was preparing this presentation, I had a list of countries that had closed borders, but now it seems like almost everybody, and the U.S. travel ban also has extended. So it seems like we are all quarantined within our own countries, except for certain emergency situations. For the list of countries that have closed borders, you can go to the Department of State website. And for U.S. travel bans, I think the news have been really good about telling us about what's going on. The foreign nationals, as of now, are barred from entering the U.S. based on the physical test. They're not about their citizenship, but whether they have been physically present in these barred countries like China, Iran, and Europe for the past 14 days before their entry. So if a Chinese national is trying to come into the U.S. for work or study, they are allowed, but they have to be somewhere else other than these countries for 14 days before they try to come in. Of course, U.S. citizens and permanent residents and their families are allowed, but they are directed to 13 designated airports where some of them, I don't know how they select these, but not all of them are subject to the health screenings, but some names are called at the inside the airplane, and they are directed to receive health screenings. And of course, they're asked to stay at home for 14 days. This ban is effective until terminated by the president, so that's indefinite. Next slide, please. The consular posts have been closed or have limited operations. Again, as of today, as of this morning now, it has spread to all countries with level 2, 3, or 4. That's just about every country, U.S. travel advisory. Unless it's a emergency situation for medical reasons to attend funerals, or the visa waiver has been denied. In such situations, they are able to have interviews, but otherwise the visa interview appointments have all been canceled. One bright possibility here was that the E2 visa, treaty trader visa, or investor visas might be possible if you can prove that the meetings that you are going to attend are urgent business matters. But it seems like it will be taken on a case-by-case basis. Also, on the USCIS side, they have suspended all face-to-face services such as green card interviews and citizenship interviews. They have been indefinitely suspended. Next slide, please. Okay, so considering the foreign workers situations, if the foreign workers happen to be in the banned countries, they cannot come in for 14 days. So they will have to go somewhere else for 14 days before they try to re-enter. If their visas expire while they're outside the U.S., then they will have to apply at the consulate, meaning that since the consulate visa interviews are canceled, we don't know when they will be able to get the interviews. So that's a problem. Now, if they are inside the U.S. and they cannot go out for consular interviews, then we can file the extension applications with the USCIS. For now, USCIS is open for such services, but in many situations, USCIS has increased their scrutiny of these applications, and it could prove to be very difficult. Foreign students who have to start their OPT internship within 60 days of the end of their programs may not be able to get their opportunities because some of these employers are closed, and that is also a problem. So what do the employers have to do now? They will have to make a list of the foreign employees that may be affected by the ban and check their status and their expiration dates, and check the State Department website for country-specific consulate info. And if any questions, contact their immigration professionals. There might be some alternatives, but for now, the pictures look very grim. Now, we are open for questions.
Thank you, everyone, for listening. I want to first give you, for those who will apply for CLE credit, the next code word, which is COVID, C-O-V-I-D. Again, C-O-V-I-D. Also, for the Nelson Mullins clients who are listening, feel free to reach out to your Nelson Mullins attorney with whom you regularly work, or any one of the panelists on the call today. For all others, let us know if we can help you. The time is an hour and a half, so we have actually concluded on time, but what we'll do is leave the call open for another 10 minutes just to ask a few questions of the panelists. So we understand everyone's time is precious, and we respect that. We wish you and all of your employees that you stay safe and healthy. But because we have significant interest on this call, we'll keep it open for another few minutes, during which I will ask the panelists some questions. Rob, can we require a doctor's note from an employee who returns to work following COVID?
Mitch, the short answer on that is Yes, and the latest guidance from the CDC and the growing understanding of the stress upon the healthcare system is that medical professionals are likely already and will certainly be in the future bandwidth constrained. So accordingly, an alternative to requiring a doctor's note is an email or some other sort of certification from employees returning to work who had been afflicted by the coronavirus or otherwise exposed to it, to just verify that they've quarantined themselves, monitored their symptoms, and ensure that they're symptom-free.
Thanks, Rob. And question for you. Can I simply agree to reimburse all my employees for the cost of COVID-19 testing?
I think that while that's well-intentioned, there may be ways that you can do it, especially if you have a self-insured plan and you may be able to amend the plan to provide for that. But if you're just looking, let's say you're fully insured and you're just looking to kind of do it sort of over on the side, it's risky and can subject you to some significant penalties. Whether you do it pre-tax or post-tax, setting it up either of those ways can still subject you to some significant penalties under the Affordable Care Act. So until we get more guidance, I would not recommend doing that.
Thank you. Roy, question for you. Am I required to provide notice to my customers, particularly healthcare customers, if one of my employees becomes ill with the COVID virus?
Yeah, generally, absent some other facts, probably not. Now, you would want to look at any contracts you have and make sure that there isn't anything in there that's going to say, okay, if there's some issue that you're going to notify us. But in a lot of cases, and if the employee is, say, going on site to your customer, or if, let's say I have a client that does durable medical equipment and they're concerned about those sorts of things, I would say that you want to follow, good hygiene. You want to be reasonable, handle this in the way that we kind of talked about as far as making sure you're not being negligent in any way while protecting privacy interests. But no, generally, unless there's some unusual facts, no real requirement to notify them unless you think that it could impact the health of that customer.
Great, thank you. June, question for you. If I have an H-1B visa holder on unpaid leave, will that employee lose his or her visa status? I'm going to go to the next question. So, Rob, can I do a combination of a furlough and reduced hours?
Mitch, yes, you absolutely can. I mean, I think that these times are going to require creativity and flexibility for organizations to meet business needs, while also dealing with economic and public safety headwinds. The key here is, we discussed earlier, is to make sure that whatever approach an employer might take, they need to make sure they do it in an even-handed manner and avoid practices that are discriminatory, in purpose or effect, particularly to members of your workplace who might fall in a protected class.
And question for you, if I need to impose mandatory unpaid leave or furloughs, can I continue to allow my employees to keep all of their benefits?
I think it's important, as I talked about during my portion of the discussion, you need to make sure it is possible, but you need to make sure that you reach out to your broker to get the approval, if you're fully insured, of your insurer, or if you're self-insured, that you have amended your document to make sure that people aren't going to lose coverage because your eligibility provisions are off or something like that.
Question, Roy, what does the recent telehealth guidance have for providers and patients?
Yeah, Recent guidance from Department of Health and Human Services around telehealth. A couple things that are really critical for any providers out there or for individuals who are looking for care. Previously, in order to be covered under Medicare, the individual generally had to be in a rural area. That is no longer the case. Now, there are still some requirements around location, but it can be anywhere. So that's been broadened, and it's much easier now to bill for telehealth services, which hopefully should open up more of that. And I think Ann before was talking about where this might be a good time to look at expanding, what you're offering to your employees could be a good time to look at telehealth. Now, on the other side of this, there are obviously, concerns about telehealth as far as, is it secure and all of that? And typically, one of the barriers to telehealth has been making sure that you have HIPAA compliant tools for that messaging and for, face-to-face not face-to-face, but via video and audio. Now, providers can use things like Skype, other things that allow you to be seen and heard that previously were not permitted. And so as long as it is not public-facing, so in other words, you can't use Facebook Live, you can't use anything that anybody can look at, but as long as it's one-to-one communication, private, and allows you to see and hear the individual, it's now allowed.
And to jump in, Roy, on the telehealth, the HHS issued a notice last night about lessening its enforcement discretion on telehealth communications, and they specifically list in there some of the permissible providers. So for anyone that's interested, if you go to the HHS website for the Office of Civil Rights, you can find that guidance, and it was issued last night.
Yes. Next question is for June. I'll repeat this. If I put a H-1B visa holder on an unpaid leave, what happens to that person's visa status?
Oh, okay. Sorry, Mitch. I must have been on mute. No, it would not affect his employment status, and his visa status will be fine. It's considered part of employment.
Thank you. Hey, and one question for you is, what happens if I delay employee bonuses, and particularly senior level folks who have executive compensation?
That's an excellent question. And actually, that's one that we did not touch on, but I think is important, especially since we're sort of in a bonus payout time of the year. There are several provisions in Code Section 409A. Some of you have learned that code section and learned to hate it. But there are several provisions in there that may allow you to delay the payment of bonuses, at least at a minimum, maybe until the later in this year. However, I definitely caution you that before you just jump up and start putting off the payment or delaying it, work with your counsel and make sure that you've got the right provisions in place and that these exceptions are available to you. Even if there's exceptions under 409A that allow you to put off some of the payments of whether it's deferred comp or discretionary, or your annual bonus program, you're still going to want to have your counsel look at the contract itself just to see if, even if the law would let you do it without penalizing you, is there some contractual violation you're going to be getting yourself into? And there are also, separate and apart from just being able to potentially delay till later in this year, there are some provisions in 409A that if you are one of those unfortunate companies who is being put in dire straits, if the payment of the bonuses and or deferred comp would cause it to jeopardize your ability to continue as a going concern, there may be some longer delays that we can put in place to give you some breathing room and liquidity. So reach out to your advisors on that.
Last question for June, and then we'll wrap this up, is I have a visiting employee on a visa waiver from a company in France, and that person is supposed to leave within 90 days. Can the employee stay longer in the U.S.?
Yes, there is a provision to allow 30 additional days for those who intended to leave within the 90 days but could not leave because of this crisis. Yes. For New York, you are supposed to show up at the deferred inspection at JFK, but for other parts of the country, we don't have the specifics yet.
Well, I want to thank all of our panelists for doing a great job. Hopefully, we have provided you information, spotted some issues, and given you some homework assignments. Feel free to reach out to us. As I said, we're going to sign off, and again, we wish you and your employees to stay safe and healthy. Thank you.